Want to know if you have a plaintiff's personal injury claim? We can help you with that. In order to have a viable plaintiff's personal injury case in Massachusetts, you have to have 4 elements. And that's the elements of negligence: duty, breach, causation, and damages. Those elements are: there was a person that had a responsibility to act in a reasonably prudent manner, and they violated that responsibility, and that violation caused you damages. We take that kind of gray amorphic standard and we apply it to the facts of your case to determine if you have a plaintiff's personal injury case. If we find that the tortfeasor caused damages to you by acting unreasonable, you have a plaintiff's personal injury case. You have to have sufficient damages. And then of course, there has to be either an insurance policy or some sum of compensation or available money to compensate you for your damages. And while the official rule of law is duty, breach, causation, damages, the kind of unwritten 5th element is there money to pay for those damages? Now, of course, people always come to me and say, well, let's sue them personally, and let's take their house and their bank accounts and their money. In most instances, the house is protected up to $250,000 or $500,000 and can't be forced sale by our homestead statute. And bank accounts, maybe you can attach, but is there enough money to really adequately compensate a person? The number one way is that insurance policy. And the question is, can we find an insurance company that's going to compensate a person for the damages and injuries that they sustain? If we can establish that the tortfeasor violated their standard of care, acting as a reasonably prudent person, and that violation caused damages, you have a plaintiff's personal injury case. So now that you know you have a plaintiff's personal injury case, what do you do? What are the steps in bringing forth a personal injury case? We break them up into pre-suit and post-suit. In the pre-suit stages, that's where we're having initial fact investigation with our clients. We meet with our clients and we perform fact investigation. The first step is fact investigation. What happened? Who was involved? Where did it happen? Why did it happen? Who's at fault? Fault is an incredibly big part. That goes to whether or not the tortfeasor breached their duty. So the fact investigation is the first stage. We request police reports, accident reconstructions. We talk with experts if necessary. We then follow our clients through the treatment process. We explain the process that as clients treat, it's their responsibility and our duty to make sure that we find out every provider they had, to request those medical records, to request those bills. And we take them and we assemble all of them into a chronological timeline that's put into a demand. A demand, as it sounds, is a letter that goes to an insurance company with each of the medical records, with the accident reconstructionist, with the police report, and we set forth that the tortfeasor breached their duty of care, causing damages. We set forth the facts of the crash, the facts of the injuries and how they occurred, and really explain how and why the tortfeasor did something wrong or breached the standard of care. And then we take the company and the adjuster through each of the treatment providers. We set forth the damages, call those the special damages, how many medical expense providers there are, when the client treated, from when to when, how many treatment dates they had, what were the results of the CT scan, the MRI? Did they go to physical therapy? How many times? What were the subjective complaints that the client made? What were the objective findings of the physical therapy, right? What was the analysis that the physical therapist made? And by what procedure or process did they use to treat that client or patient? And we assemble them into a timeline and we make a demand on the insurance company. Through the process, we also learn something that we get to know that a lot of other states don't. How much are the policy limits? How much insurance is available for our injured client? And we base all of that information on a demand that we make. We then go into the process of negotiating or trying to negotiate a settlement pre-suit, because we're still in the pre-suit range. And this can take time. We can take months. It can take very long. Insurance companies tend to review cases, evaluate roundtable with their managers, and then come back to us with questions that require us to get more information. Oftentimes, clients are still treating. Our approach differs from some other attorneys who are looking to resolve your case as quickly as possible while putting less time in it. You see, most plaintiffs' personal injury cases are done on a contingency basis, which means the more time you spend on it, the less your effective hourly rate is. And what a lot of people and plaintiffs' attorneys do is they want to settle the case as quickly as possible, using and putting as little time as possible into it. And one of the things that sets us apart from those attorneys is that our entire practice is not just based on a plaintiff's personal injury case. We have cases that are bringing in revenue hourly and daily and monthly, and we don't really require and rely on the plaintiff's personal injury cases to make payroll, to cover our overhead. So we can really take those plaintiff's cases and nurture them and hone them and kind of get as much as possible out of them. We can squeeze that orange for as much of the juice that's in it to get the best result possible for our client without having to worry about how long is it going to take and what can we do. We can really nurture those cases. And what we've found over the years, and what I learned from being an insurance defense attorney, is the longer these cases sit and the more adjusters they go through and the longer they're on the books of the company, the greater the value is. And that also allows our clients to continue to treat and really flush out what are their injuries. Are they at a medical end result? Because in the end, you don't want to settle a case if a client isn't at a medical end result because you don't know the true value of the case. You need to know what the value is of the case before you can assess a value, before you can put a value on it, before you can really determine damages. A client needs to be at a medical end result. I would never want to settle a case in which a client is still treating or has future treatment to do because I feel as though it could be shortchanging them. Because an insurance company is only going to value cases on the today damages. The future damages are a little amorphic. Clients often come to me and they say, I am going to go for surgery. I may go for surgery. I need surgery. And every time I have this conversation with an insurance company and I say a client may need surgery, they don't have it. They elect it. They say everyone needs surgery. Everyone may need surgery. And all of this goes into the negotiations pre-suit. The next step, if negotiations break down, if the client's at a medical end result, and we're just not satisfied with the amount that's being negotiated, we put the case into suit. We file a complaint with the court. A lot goes into that, a lot. We need to know all the damages. We need to know all the facts. We need to know what the anticipated recovery will be to determine if we're going to file in district court or superior court. Are we going to file in the local district court for a case, or are we going to file in the Superior Court of Massachusetts? We take into consideration who the jurors would be. Is there a higher perceived value in the Superior Court versus the district court? Is there more red tape? Is the time through the process longer? And these are all factors that we decide when we're determining where and when we're going to file suit. We also need to consider jurisdictional issues. Where did the event occur? Where are the parties from? Where do they live? Where did the crash occur? And all of that goes into the determination of filing a complaint. Once we file the complaint, of course, you have to lay out the elements we've talked about, the duty, breach, causation, and damages, make a claim for a jury, fill out either a civil action cover sheet or a statement of damages, and file. We are then given a summons. A summons is then served on the tortfeasor. We would send a constable out or a sheriff, and they would serve. And eventually, after service is made, the insurance company will file an appearance, or their counsel will. The insurance company will file an answer denying everything. They'll put in affirmative defenses that are kind of get out of jail cards for you. That are, this didn't happen, or you didn't follow this rule, or you're precluded from bringing this claim. And that will start the discovery process. Discovery is broken up into written discovery, or paper discovery, and then the deposition phase. Paper discovery might include interrogatories. Interrogatories are a series of questions that are asked under oath that need to be responded to in writing. It's a very strict procedure in which insurance defense attorneys will ask questions, and we in turn will have the right to propound interrogatories or written discovery on the defense. There'll also be requests for production of documents. Those are just what it sounds like. Those are a series of questions that will request documents. Let us have the police report. Let us have your last eye exam, your cell phone records, coverage, insurance. To the plaintiff, let's see your medical records. Let's see your medical bills. And that's that paper discovery phase. It can get time consuming, it can get thick, it can really affect it. And the paper discovery also can include what's called request for admissions. Request for admissions are a series of questions that are either admitted, denied, and if within a certain period of time are not either admitted or denied, are deemed admitted. So this is really important to be on top of request for admissions. And these are all tools within our toolbox to fact investigation and to establish our case. One of the techniques we use is we write our closing argument first. Our closing argument is what we intend to prove. We write that first. We start from the end and work backwards. And the statement of our closing argument is all the facts and evidence that we need to prove. What do I need to prove that the tortfeasor or the person who caused these injuries was at fault? That they were acting unreasonably? Were they drunk? Were they texting? Were they not paying attention? Were they speeding? What are those things we need to prove, and how are we going to prove each one of those things? We keep a keen sense through written discovery as to what they are. Usually after we've exhausted written discovery, which could also include issuing keeper of the records subpoenas, meaning going to a third party and saying, you are hereby commanded to give us these documents. We can then get into depositions. For us, depositions are the fun part. That's almost like an interrogation, if you will. Some people don't like to think of it as that, but it kind of is. You basically put the person you're deposing in a conference room. There's a stenographer there typing every single word. And we get to ask the other side a series of questions. And similarly, our client will need to be deposed and asked a series of questions. We prepare all of our clients for these depositions. We have mock-ups, we have practice sessions, and for some, we have a conversation or two because our clients are savvy and the facts are simple and it doesn't require as much preparation. Sometimes for our clients, it's an anxiety-provoking event. For everyone, it's an anxiety-provoking event. We go through the deposition process, again, fact-finding. What are the elements we have to prove? What are we going to prove in our closing? And how do we get there? And that's what depositions are really for. After depositions, we may have a case management conference or a pre-trial conference in the court. And those are all a time for us to get before the court and to have the court learn about our case, set a schedule of when things are going to happen, and ultimately set a trial date. And all of this is about preparing for that trial date. We want to prepare our case from day one until the day of trial for that trial. How is a jury going to look at these facts? And how is a jury going to hear our closing argument? And what facts are we going to be able to get into evidence to prove what we want to prove and say what we want to say in our closing argument? That's what a trial is about. How can we humanize our client and talk about how this event affected their life, their family's life, their spouse's life? How can we convey that message? And of course, our most educated, and I don't mean educated in the sense of going to school, I mean educated in a sense of the clients that come to us and talk to us and learn, and we learn from them, are the ones that are most successful. The cases that actually go to trial, that we can convey our client's story in the best manner possible, are the ones that win. You have to have a righteous client, a client who wasn't at fault, an insurance policy. But at the end, we're going to put the best case possible, and we're going to draw from our experience to do it. Then comes the closing argument, where we surmise all of this, we hopefully connect with the jury, and we allow the jury to act as that conscience of the community and render a decision that is hopefully in our client's favor. Jury comes back, hopefully the client is happy, we're happy, and we provide closure and a sense of security to our client, and have hopefully made our community just a little bit safer of a place, because that jury said we're not going to accept that behavior in our community. If you want to learn more about that, give us a call. We're happy to chat about it. Call us today.